chances of success in the H-1B cap in year 2025, we're going to be talking about what can you do to have the best chance to get that H-1B approval. Obviously, we cannot control the lottery selection, but we can control making sure it's done right and what goes after it. I'm Sam Shihab with the law firm of Shihab Burke, and with me,
Brian Burke, also from Shihab Burke. Yeah.
And we spend 1 hour with you every week at 6 o'clock Eastern Time to discuss topic of interest in employment immigration law and to answer questions and get feedback from you and learn a couple things from you, and maybe perhaps hopefully you can learn a couple things from us. So the H-1B topic is an important topic that we bring about now because we are approaching the
H-1B cap registration season. It opens up in mid to late March when employers can submit their candidates for the H-1B cap.
Yes, and this year USCIS made some changes to combat collusion, company collusion.
Yeah.
This is the bad word, collusion, by the way. And they
multiple
have
registrations on behalf of companies getting together say, hey, if we both register for John Doe, we'll increase John Doe's chances of getting selected. And basically, we want him. Great,
And as we said before, USCIS created the problem, and finally USCIS solved the problem.
Yeah. The net result this year, in terms of our topic, increasing your chances of success in the H-1B cap fiscal year 2025, I would say the average person does have a better chance of selection because the average person is not going to be registered through, 10, 20 companies, meaning they will have a better chance due to the change in the system that results in one person, no matter how many times they're registered in the cap, no matter how many companies, they get one chomp at the bit, one opportunity to be selected in the cap, the 85,000 visas available. Yeah.
And if you went through 10 companies, these 10 companies will receive notice of selection, and you decide to file with the company you're most comfortable with.
Yeah.
And we're going to talk about
that for sure. Yeah.
That issue. And one of the things that I like to kind of break this down into, and we can probably talk about this forever, because we do.
I can talk forever in general, Sam.
Is a substantial number of H-1B cases in this office, and we have quite an experience, and we've seen the good, bad, and the ugly in this business.
Yeah.
And we can share insight.
Yeah.
For me, in my simplistic analysis of this, is that to me, there are people inside the U.S. who are on OPT, CPT, F1 status, or H4.
Yeah.
And then there are people who are outside the U.S. who are on no status.
No status, just somebody outside the United States, yeah.
And clearly now they are on equal footing, except those with the U.S. master's degree have an advantage.
Well, why would you say that they weren't on equal footing before?
Well, they're on equal footing now for sure.
Yeah, I would agree. One person, one opportunity.
They were not on equal footing before is because before they were able, people in the U.S. be able to interview with more than one company and have more than one opportunity. So the chances of them being selected in the lottery is higher because they're interviewing with company A, they're here, they can go fly to Vegas and interview with company B, and they can go to New Jersey.
Yeah, I guess there's, no matter what, I guess the point is that there's more access to U.S. employers if you're in the United States. There's people who might not have considered you if you're outside the country who would consider you sponsoring you if you're here. Okay, sure.
So that's why.
Yeah, establishing relationships with people, getting a job in the U.S. while you're on student status, H-4 status, and then saying, hey, throw me in the H-1B cap. Sure, okay.
So for me, I'd like to kind of talk about both of them.
Okay.
The first thing is the people here in the U.S. The very first thing I would like to let them know that, and I get a lot of phone calls from companies and individuals about H-1Bs. It's almost always when the employee, not all the time, but often, when the employee making the phone calls, that's my clue that the company is not interested.
Yeah, for sure.
And I had this email from HR after this nice guy called me from California, and the company HR emailed me and said, we absolutely support our employees' H-1B petition, but we will not pay for it.
Well,
And I said, you cannot do both simultaneously. You cannot support and not pay because the law requires you to pay. So your clue, your number one clue, if you're here in the U.S. and if your employer tells you, go find the lawyer, that's your first clue that they may not be vested into it because they don't want to put the effort in it.
yeah.
And that's the thing I want to kind of share because I get a lot of those people and I like to tell them, it doesn't look like your employer is interested, but I don't want to say that too harshly. I have to be nice to them. But oftentimes, those cases don't go anywhere.
I would give that, maybe 8 times out of 10, those cases don't go anywhere.
I give it 4 out of 5.
Yeah. Yeah. I don't know. I just wanted to choose 10. I don't know. So yeah. I would agree with you. That's a very great starting point.
So for the people, this is your success in the H-1B cap is to understand your employer, and if your employer is letting you do the runaround, look for another one, or have a backup.
Yeah.
That would be my advice. So back on track here.
Yeah. So I wanted to bring up. I think the most interesting thing about this is past years multiple registrations. The benefit of multiple registrations was to more registered companies equals better chance of being selected in the cap, right? Great. But I think what is intriguing and interesting this time around is I think there's still definite benefits to registering through multiple companies because what I'm thinking about now is, because getting selected in the H-1B cap is just, one step. Next step is actually getting an H-1B filed and approved on your behalf. And the bottom line is it is kind of a volatile world we're living in, especially with the fields that most of the people, engineering and technology, that most people on H-1B visas are in.
So that's an interesting question, and that's a point of debate that we can probably spend a lot of time on. And this is maybe outside the practice of law a little bit, kind of a human common sense things, is you have one chance per case. You apply through per person.
Yeah.
One chance per person, right?
Yeah.
You know that. If you have a good relationship with an employer, and then you go and the employer finds out that you've now shopped 20 different employers, and you filed 20 different times, that employer is taken back because they're saying, maybe this guy is not committed to me.
Yeah.
Maybe this guy is not for me. Do I spend the money? Do I not spend the money?
Yeah.
Or do I,
it's a classic, or do I think as soon as I get this guy approved, he's going to go file to change employers to somebody else? Well.
And is that his nature, even if he comes with me now, would he move on 6 months later?
Yeah.
Now, I'm not saying don't multi-file. What I'm saying is consider your options. Don't just run away blindly and multi-file because you could be potentially ruining a relationship. So you have to be careful.
Well, I'm gonna double down on the opposite approach. You are right. There are people who can be offended.
I know I'm right.
But I know I'm right. Sam, I've talked to people in the last couple months. I got laid off from Google, Microsoft, whomever, right? And putting your eggs in your tech giant's basket when their basket might have a hole in the bottom. We're gonna sponsor your H-1B. It's possible to go up in smoke, and if you've registered with one company, well, congratulations, you beat the odds, you got selected. Well, if the one company that sponsored you doesn't want to actually file the case, your H-1B selection is useless.
But precisely what you just said supports my point of view.
Explain, please.
Thank you. I have no problem with the large corporations.
Mm-hmm.
You're traded. On a given day, your commodity goes up and down based on their demand.
Okay.
Most people don't get hired by these big companies today.
Okay, I'll give you this one. Yeah.
They get hired by smaller companies, mom and pop companies, mid-sized companies. These companies
handshake relationships, friendly people you're friends with, people you're referred to by friends. Sure.
And these people is where it gets a little bit difficult.
I've had those conversations with clients and employees of those clients.
And that's why I'm not saying do not do it. I'm not saying that at all. What I'm saying is be smart about what you do. Be smart about what you do. Consider consider what you're doing. Now, last year, 700,000?
Yes, somewhere around there.
Okay.
Yeah.
Probably it'd be $1 million this year.
You think? I think they're.
I don't know. I don't know. I mean, I don't have a crystal ball.
I think less. I think less. I think that there will be less incentive for people to choose multiple companies. I still think there will be, and there should be multiple registrations. But the company, we read a notice of intent to deny on an H-1B cap case last year that somebody sent us looking for advice. From a group of companies out of somewhere in really kind of the heart of the country, Midwest state, where it was, an accusation that somebody had been registered through like 11 companies. I think it was like that. Mm-hmm. And I don't see the need for something like that. I don't see the need for one, company to start up another company. Yeah.
The collusion is gone.
Yeah.
100%.
Yeah. Yeah, registering through my friend's company is not going to help me get you when you get selected through the friend's company, and my friend doesn't want you. So what's the point?
So would you agree that the number of cases filed this year?
Now you're agreeing with me? I would agree.
No, I'm gonna say, would you agree? I'm asking you. I'm not agreeing. No. But I'm saying, would you agree that the number of cases filed this year minus the number of cases filed last year, or the other way around, equal the number of cases likely that there was fraud last year?
I think that's what USCIS. I think if I understand those numbers in my head, I think that's what USCIS claims. Yeah.
Yes. All right. So choosing the employer is a discussion that is important.
Yeah.
And there are two types. There's a company and there's consultancy.
Yeah, and they offer different things. I mean, in terms of if you walk into the consulate or go to USCIS or go to USCIS or walk in the consulate with H-1B approval notice from your Silicon Valley giants, your Apple, your Google, your Netflix, I'm forgetting Microsoft, big giant names. Well, those guys can put out those they're going to prove those guys as H-1B cases constantly, regularly, because unless somebody has really goofed up the filing, I'm going to believe Microsoft has a need for a software developer. I think I can wrap that around my head. Whereas, so great, but you are a tiny little cog in a great big giant machine there, and you can be you could be amongst the 11,000 layoffs, and then your H-1B selection is toast. Consulting companies, they're going to get more scrutiny on terms of H-1B approvals.
Not as much anymore, but go ahead.
You're right. So in the climate we are in right now, I agree with you that it is not very easy, but it is relatively easy versus years past to get an H-1B approval. Great. Still, at the consulate, to get an H-1B approval from USCIS, at the consulate, they are putting increased scrutiny in the last couple of years upon, hey, if we're sending you to the United States, has your employer documented that there is work available? Totally outside of USCIS regulations, which I think should control on this, but so be it. The consulate is more inquiries to employers, clients, saying, hey, we have so and so here at the consulate, waiting for a visa, and can you confirm X, Y, Z for us so we can actually make sure that everything he's told us here in this interview is accurate. Yeah. And so that's kind of it. I don't worry about those H-1B cases getting approved, but we have to talk. There's a little bit of an elephant in the room in that there's a presidential election coming up in November. Not everybody goes for stamping, on October 1st. And if you're going for stamping, in the new year when there's a new administration in place, I would question though. If that happens, I would be interested to see what kind of policy shifts you see in the immediate thereafter.
Good point.
Yeah.
Registering in the U.S. master cap correctly, or not registering correctly. I guess you are guaranteed in the lottery if you don't register in the master cap, regardless.
Yeah, that's a great point right there. Yeah.
But it is if you're registered in the wrong cap and you're selected, your case is toast.
I'm going to say it another way. So you're never wrong to be in the bachelor's cap. The worst you've done there is you've deprived yourself of an opportunity of 20,000 visas additionally that you might have been eligible for. Yeah. But if you wrongly put your name in the master's cap, if you're your degree is not from the U.S. or it's not from a public or otherwise not-for-profit institution, a couple other requirements on that list, and it comes time to file your case, you go, yes, selection, and you come to USCIS and say, here's my credentials, and they say, well, that's not from the United States, your CAP selection is worthless.
And what are these requirements so people hear it clearly?
The critical ones are the school must have been accredited at the time you received your degree, because the school must be accredited, and it must be from a public or nonprofit, otherwise nonprofit institution. On the list, there's also one that it actually has to offer undergraduate degrees as well, to my recollection, but that's one that very rarely comes up. It's literally, it's in the regulations at something 1001A. I haven't read it for a while. But the number one, 99% of cases are going to be covered by, as long as it's accredited at the time you received it, and that's going to, honestly, most of them are going to be accredited, from a public or otherwise not-for-profit institution is the real thing that people fall in a hole on.
Graduation date. What's the magic timing of the graduation date?
So it's fun. It's been an interesting change in the last couple years because they changed the CAP to the electronic one. Essentially, you must have completed that degree by the time your H-1B case is filed with USCIS. It used to be, you had to have it by April 1st because you were filing cases on April 1st. Now it's basically you must have completed all the requirements of the degree by the time you file your case.
So you do not need a certificate in hand.
Correct.
You need a letter from the dean that says you have completed all the work and you're waiting for the ceremonial activities.
Yeah. So yeah. I guess your point is if the degree is actually completed, that's enough to meet the requirements. But not just I finished my classes is good enough, because how's the government going to know that? It's going to be a letter from the school that says yes, so and so has completed all the requirements for their degree program. Is typically what my letter would say.
And they would not issue that letter unless you paid all your
that's a very good
tuition.
point.
Because we've had those, right?
Yeah.
If you haven't paid your tuition, they say, yeah, you completed everything. You owe us money.
Yeah, but you're not eligible to get your degree.
Here's the letter. Give me the money. I'll give you the letter when you hand the money.
Yeah.
All right. Excellent. So switching gears to those who are outside the U.S. Now these guys now have an even playing field, because now one lottery. So the guys here in the U.S. who can interview a bunch of different companies and have multiple selection, that is gone for them.
Yeah.
So the people who are outside the U.S. and the people who are inside the U.S. really mathematically now have equal opportunity, except for those U.S. masters.
Yeah, yeah.
Which is good for the guys who are outside the United States, not as good for the guys who are inside the U.S.
Yeah.
It is what it is. These are how the rules are that we're living by today.
Yeah.
So for those who are outside the United States, a lot of them have a 3-year bachelor's degree, Brian. So what do you tell us about that?
So in a lot of Commonwealth countries, well, let's start why it's a problem. The way the U.S. immigration laws are written is that an H-1B position must be one that normally requires a bachelor's degree. And that's based upon the U.S. requirement, and a U.S. bachelor's degree is 4 years. So if you come to USCIS, the Immigration Service in the United States, with your 3-year bachelor's degree, they're going to go, does not equate. And well, I guess, is there a way around that, is the question. And the answer is yes.
Possibly.
Possibly, yeah. So, and this applies, well, generally speaking, let's say you have a 3-year computer science degree from India, which is a pretty common 3-year degree from India that we see. Mm-hmm. Basically, the USCIS has a rule called the 3-to-1 rule, where they say 3 years of professional experience in the occupation is the equivalent of 1 year towards a degree. So great. So if you have a 3-year foreign degree that's kind of related to your field, plus you have 3 more years of experience in your field, that can be a path to getting H-1B approval. The devilish little requirement, though, is they're going to require some evidence of that. Your resume is not good enough. This is something they've kind of increased their requirements on in the last couple of years. What they expect to see is detailed letters from your prior employers that basically say, so-and-so did these duties, and at the same time when they did this, they were working with other people who had bachelor's degrees in their fields. So basically, they want to make sure that you are getting professional experience with professional people who would be comparable to those who would have an H-1B visa in the United States.
Progressively advancing?
I don't believe it's required in the 3-to-1 rules.
Okay.
Yeah.
Okay. All right. Sounds great. And for those who are in the U.S., the big one is have they maintained status, right?
Yeah.
It's not a killer,
Yeah.
but it's a killer to the change of status because an H-1B application really is two things happening at the same time. People don't understand
Great
that.
point, yeah.
Yeah, it's the H-1B petition, which basically focuses on the qualifications and the job offer in the U.S. You know, the degree,
Yeah.
lottery selection, filed by the employer who has a job for you. That's all what they look for. And then there's something else that's going on the side, which is the status.
Yeah.
To shift you from H4 to H-1B, from F1 to H-1B,
Yeah.
and that requires maintenance of status.
Yeah, it's always a sort of a hard conversation, because I find myself maybe like once a month have to explain this to somebody on the phone, and I basically, it's like, my version of it, one of them is, are you a guy or gal who is somebody they could give H-1B status to? And the other one is, are we going to give H-1B status to you right here through this application? And Sam, students in the United States, I, in my estimation, think that a lot of them inadvertently violate their student status. Sometimes they'll take, side employment or any employment that are not allowed.
Not a lot of them. But go ahead.
Not a lot, not all of them. Some of them. I'm gonna say these are the common things I get asked about.
Yes.
I talked to somebody recently who was, oops, I didn't know I was allowed to drive Uber on the side. Oops, I forgot to update my school when renew my CPT from semester to semester. And oops, I needed money. I was working at the bodega where they didn't care about my employment authorization. It happens, and those things can impact in my version, are we going to give you an I-94 part of that? And there's a strategic question to be kind of talked out with your employer and your immigration counsel of, do you have a status issue? And the question is, do you request an I-94 if you have a status issue in your background? I guess is where it comes around, right?
Right. Well, I mean, you're required to be truthful.
Yep.
That's very important. And you have to be truthful.
Well, yeah. I would say this, though. On the H-1B I-129 form, they don't ask, has your employee, maintained, violated their status in the United States? It's always kind of a
missed question.
A missed question. I mean, they would require probably the individual to sign off on it, but in a separate, sort of addendum to the form. Maybe they don't want to do that, but agreed. Yeah, a missed question for sure. But it's something that comes up when you go to the consulate, though. So let's say maybe, I had maybe more than the allowed amount of unemployment time on OPT, right? Mm-hmm. And okay, fine, I'm going to not request an I-94 because I want to be honest that I've not maintained my status, and we'll just request that they approve me as a person who is eligible for H-1B status rather than somebody who has that and is going to get an I-94. So you plan to go for stamping. Well, and that then comes your issue of honesty, because they're going to ask you on that visa application, hey, have you ever failed to maintain your status in the United States? And that's where people get in trouble.
Not truthful, they hide it.
Yeah.
And some people, it works. It doesn't work for everybody.
Yeah.
And if you have a problem like this, talk to counsel, because there could be a solution where you don't have to take a risk of lying and still get your case approved.
Yeah.
I mean, the USCIS doesn't expect you to be perfect, but at the same time, they really, and the State Department, really don't like it when you're not.
Yeah. Yeah, I mean, people come to us all the time with problems that would be a little bit small, and then if they are untruthful about them, it kind of...
Massively problematic.
Massive, yeah.
Yes.
And it's a question of, people, sometimes, I can't say it works because I never can condone it, but, sometimes I am baffled by what the U.S. government can't figure out, and sometimes I'm astounded by what they do, tell people through their security investigations.
Yes, with social media searches. 6:25 p.m. We want to answer everybody's question. Do you want to throw in a word or two on stamping?
Well, it's kind of down the road, but it's kind of what we were talking about earlier. It's the Department of State has increased scrutiny on these, and that's kind of the, consulting company. We were sort of talking they're what might more likely to scrutinize a consulting company, but we're not really having problems with people getting stamping in the long term. They might, call the company and ask the client, but people are getting stamping consistently, and I'm pretty conservative with my words, and I'm not hearing problems for anybody. Like, we're having massive problems with people getting stamping. I guess always on your first stamping, it's going to be H-1B stamping. It's going to be more scrutiny than prior ones, because they're going to want to think about things like, were you honest with us about your status? You really maintain your status in the United States when you were when you're a student? There is more that can come up in your first H-1B stamping. Is, I guess, my thought on it. Yeah.
Last point, and then I will jump in. I'm not going to take too much time. If your employer doing the H-1B in-house, not through counsel, maybe they're smart people, but I can tell you 90+%, the quality of that application is not as good as an application filed by an attorney.
Yeah.
So in terms of counsel selection.
Yeah, good point about that. You're not allowed to pay for the cost of your H-1B petition, for sure, but you are allowed to pay for your own counsel. People call us up every now and again and say, I want advice on something specifically H-1B related. It's not about filing. I'm not paying for you to file a petition for me. I'm not paying for you to.
I need my own counsel to advise me on what to do, what not to do. Yeah, am I on the right track?
Yeah, I'm in a dispute with my employee. Yeah, things like.
Am I on the right track? I'm not even in a dispute. I'm negotiating a new job.
Yeah, those are some of my favorite consults to take. I love doing them, and you guys are allowed to do that. Pick an attorney of your choosing. Some of them will talk with you for free. Some of them will charge you a fee. Find somebody who does employment-based immigration, and it's always a fun consultation. Those kinds, I think.
Yep. And we come now to the part where we answer your questions. And just a reminder, do not rely on what we tell you. We don't know enough about your case. A lot of times we struggle with the very small information that we receive, and sometimes we may be answering a different question than one you're asked, or maybe completely not related to you. So there's no attorney-client relationship established, and you're entitled to hire an attorney of your choice to help you with your case, and you should take advantage of that. Without delay, let's take the first one, Brian.
Sure. From Hari Guru. Hi, Sam and Brian. Hi, Hari. Thank you for all your service. EB3 India, priority date August 2003. We as family applied for AOS in October 2020. Recently got 5-year EAD extension, which is valid till February 2029. AP is pending for all of us. That's got to be August 2013, right? In lieu of 2020.
I was going to say.
Yeah. Let me see here. But here's Q1. Well, this says there's a Q1 here, but I'm not.
To skip down to.
It's like a part
yeah.
2. Okay.
Yeah.
I, primary still on H1B. Wife and elder kids started using green card EAD. Younger one is on H4. In case of job loss and applying change of status from H1 to B2, can I only COS to B1, independent still on pending AOS? So the answer as I understand it, and maybe your understanding will be different from mine, is that this is an individual who's on maintaining their H-1B status all their long day, and as a spouse, is a child that's maintaining H-4 status still, and they can independently. You're a kid, you can be on H-4 status, but there's a wife and another child that are using the green card EADs because they're allowed to. And the question is, well, can I? Who of us can change it? If I lose my H-1B job, who of us can change to B status? And my answer has to be. Well, as soon as I start giving my answer, I'd say maybe not. But I would say, in theory, the people who are still holding status, being H-1B and H-4, might be able to apply for B status, because one of the requirements to apply for any non-immigrant status is that you must be in status at the time you file it. But the reason why I paused, Sam, is I said to myself, do you think they're going to approve changes to B status for people with pending I-485s?
So it is not approval what you're going after. Obviously, yeah, what you're going after is staying here in the United States and allowing yourself to later on apply for an H-1B, again, when you find another employer, and then request USCIS to approve both at the same time to get you back.
So the story
and that's what USCIS said they would like to do.
So the story is, I lost my H-1B job, a 60-day grace period. I didn't find a job in a 60-day grace period. Before the end of that, you filed a change to B, and then you find a job while your B is pending. You file with H-1B with the premium processing, get back into H-1B status.
And then they should approve both of them per their informal policy.
Yeah.
So the answer to the question, yes, if your spouse and or your child are on advanced parole, one or both, you could alone file for a B1. And if you want to keep your child on H4, that's fine. Then both of you will file to B1, and then file H1 and H4 after you find a job, and request USCIS to adjudicate both so they get you back on H-1B.
Yeah. Well, the other family members that have pending adjustments and have used the green card EAD.
They're maintaining a green card EAD.
Yeah, they are allowed to stay in the United States pursuant to that, so I wouldn't be terribly worried about that.
And let's later on assume that USCIS does not want to approve that B visa for whatever reason.
Yeah.
You can leave the country and come back.
Yeah. Worst case scenario.
On a stamping or get back on EAD.
Yeah. Yeah. So there's
I think we skipped one above.
No, there's one here where it's from somebody named Gangadhara.
It started but didn't go anywhere.
Yeah, it didn't go ahead. So get it in there. We'll try to get to it for you. So from Tech Dreamer, so that's a term that kind of it's the concept of the dreamer, but in the tech world, you're somebody waiting forever for an employment-based green card. I imagine it's kind of a descriptive name. 2 questions. I traveled to India in 2022 and came back to U.S. on AP after 1 month. My I-94 issued for a year. I applied my H-1B extension in 2023 and got approval and currently working on H-1B. Okay. Fantastic. Bing. What status should I mention for immigrant status at your last arrival in I-765 form? Will it be advanced parole or H-1? And the other question, my I-131 extension is pending for 9 months. Can I apply for another I-131 with EAD extension? Is there any risk involving that?
Okay. So what status is he on?
Right now he's on H-1B, it seems.
Assuming he went back, he joined the same employer.
Yeah. USCIS approved it and issued the I-94 per the story that's told here.
Yeah.
But honestly, status at last entry, because they asked 2 questions in the I-765 form. I believe it's what is your status at last entry and what is your status, what is your current status? And the answer, I guess, for me, the answer has to be, parolee when you entered H-1B after you were issued an H-1B I-94 pursuant to that policy. Yeah.
Agree.
And the other, the sort of perennial question, Sam, it's can I apply for another I-131 with EAD extension?
The answer is yes. Yeah. Do it, and do it now before they change the fees.
Yeah.
Do it and apply for both of them, and there's no risk. You're going to have both of them. One is going to be approved, one is not going to be approved. You know that. They cannot approve both at the same time. So the risk is one of them is going to be denied. Well, you know that. Yeah. One of them will be approved more than likely. Yeah. So yeah, I would do it.
Yeah, it doesn't. I don't really
get it out before the fee increase.
Well, here's that. I think that's the question that we were looking for here. Starting with I am.
I'm working for a company A, and contract was ending, so I got off to an offer for a company B, and they have transferred H-1B, and it's approved, and they have filed H-4 and EAD for spouse, and wanted to be a company where I would like to know what I'd like to know what the implication if I don't join the company B.
Oh, interesting.
So did company A took you back?
Yeah.
Well, let's go back to the question, Ryan. I want to know whether it was approved, right?
Yeah, change from company B.
But he hasn't started.
Yeah.
I'm assuming, right? And they have transferred H-1B approved. They want to be I think want to go back to company A.
I want to be on company A. I see it. Yeah.
Yeah. So if you haven't left. Yeah. Company A, you can just stay in company A. It's very simple.
You don't. Yeah. I mean, you don't really have control over that H-1B. Anybody. I mean, you could have told them no, don't file that H-1B, and they said we're going to file it anyway.
Even if you told them yes, even if it was approved, after they told you said yes, you can just say I'm sorry, I apologize for wasting your time and your money, and I'm staying with company A.
Yeah, if you've joined, well, how about if you've joined company B, Sam, even just for a day?
So you can still go back to company A for a very old policy.
Yeah.
Extremely obscure rule. you could go back.
I know. I think you're thinking about the Simeo policy. That's
Oh no, not the Simeo. No, this policy is decades ago.
Well, it's been implied and implied, but that you can, if you have an existing H-1B approval, you can go back to the other company.
This is, I'm going 20 years ago, and I don't even remember a memo on it, but it is something that we've always advised our clients. He wants to come back and join me, but I have not canceled the H-1B. And we often say do it, and we've never seen an issue with that.
Yeah.
So this is something that is very old rule. So yeah, you can go back to company A, but
yeah.
I'd like to go back and see that memo, find that memo. It'll be interesting.
Yeah. I mean, I mean, in this scenario, I would want to think more about that scenario because if you join, USCIS wants to know when you change employers, you know, and I would love to argue that, but
if the prior H-1B is not terminated, you can go back to it. That has been the interpretation all along.
Yeah, yeah, and that's out there in the more recent policy memo that's implied that if you can go back to a prior H-1B approval, essentially, but. First of all, if everybody's doing their job, they should be withdrawing your H-1Bs when you leave the company.
Not everybody
but
does
again,
that.
if the answer, I mean, this is the sort of thing that there's an employer's immigration counsel is involved as well. They have to have that level of comfort as well to advise your employer on that.
Yep.
Yeah. So, going to keep on going from Senthil Kumar. Sam, would you like to?
Sure. Hello, good day. My priority date is June 2018, EB2 India, and working in IT company. Do I have options to upgrade my I-140 approval from EB2 to EB1 category to get faster green card? Thank you. Well, I like easy questions. The answer is yes, as long as you qualify, right?
Yeah.
So a priority date is transferable between EB1, EB2, and EB3. Without a problem.
Yep.
And if you qualify for EB1, and we're seeing really consistent, strong approvals on EB1s recently.
Yeah, I tried. I did an O1 visa recently where I thought I don't think they can approve this. Approved without an RFE. Different, similar requirements, different sort of things they're giving away. But it's a pleasant climate for immigration right now.
They're basically, honestly, they're doing what they're supposed to be doing because preponderance of the evidence.
Yeah.
If you prove your case 51%, the case should be approved. That's the law. And before they were really asking people to prove it to a 90% certainty.
Ooh, upsetting. I've written a lot of first drafts of letters, uppercase, saying this. One of our for our RFE requests, so we almost always include a statement saying, reminding it's a preponderance of the evidence, gang. It's any less true, and it wouldn't be,
Yeah, so if you have a case in which you can prove it 51%, by law it should be granted, and we see something around that, maybe not 50%, maybe 60, 70% they're getting approved. So yeah, answer is yes, and EB1s are getting approved regularly right now.
I mean, I'm going to maybe maybe educate a bit on the concept of it. If you do EB1, there's 3 categories of EB1. There's extraordinary ability. There's a list of 10 criteria. If you can meet 3 of those 10, you can stand a plausible case for an EB1. There are professors and researchers. Well, that's for professors and researchers. Most of the population won't fit in there. And there's EB1C, international managers and executives. I would say the number one thing that people need to understand about EB1C, international managers and executives, is that it requires you to have been employed abroad by a company related to your sponsor in a managerial role.
Are we still doing the courtesy evaluation, or are we shutting that down as we're getting close to the cap?
If somebody says, I have a little bandwidth for those.
So we have some, but we may be closing that for a short period of time because of the H-1B cap and then reopening it. But maybe for another week or so, we maybe still be taking these evaluations. And
they're always fun conversations. You get to learn about, if somebody really thinks they're a legitimate EB1 extraordinary ability candidate, they're usually doing something pretty cool in an interesting field, and it's always fun to talk to those people.
Yeah.
And that's sort of the same question. I think somehow it got submitted twice here from Senthil Kumar. From Arun. EB2 priority date, April 2012. Originally filed I-485 in EB3 in October 2020. Did a tub in February 22 and changed company in June 2022. New employer filed tub again in August 22. Am I in EB2 or EB3? So a great question. I'm not sure anybody really truly knows the answer to that question.
Well, so the employer cannot file a tub.
That's a good point.
So that's the thing that confuses me. You filed your own tub.
Yeah.
Because it's your own adjustment, doesn't matter.
Yeah.
But obviously you have an AC-121 transfer to the new employer. But why would you file a tub in August 2022?
Maybe it's hard for me to remember, but maybe that priority date was final action current in August of 2022. Maybe they again.
So do you think the second tub was back to EB3?
I would suspect, yeah. I would so
originally filed EB3 in October, then tub in February 2020.
Presumably to EB2,
and then filed a tub back.
Yeah.
So
I see what you're saying. Like 6 months later. So this illustrates the point why it's really kind of hard for us to kind of we don't give really legal advice on this. We sort of talk about interesting things. This is what I describe it. So
if the second one is a tub back, let's now do a little bit of a hypothetical here.
Yeah.
If the second one is a request to tub back to EB3, that's basically a withdrawal of a tub.
Yep.
And a withdrawal of a tub is discretionary.
That is true.
And USCIS.
However, they also say tub's a one-time thing, except for maybe movement around in the employment-based.
We can accommodate. So I think you're probably in a position where if you have a friendly USCIS, which we do today, although your priority date is 2012, it's coming up, right?
Is that current right now? Well, Sam,
May 2012. For
April 2012 is his priority date. So yeah.
Yeah, it is.
That's dates for filing. Is it current under file action?
Let me see here.
It's current in EB3, and it's so okay. So I see the issue here. So India, April 2012 is current in EB3. Because that's in July 2012, but it's not current.
And close in EB2.
Yeah.
So I think you should push for requests to adjudicate under EB3.
Sam, I have a story. I have a recent anecdote on this front.
Sure.
We have a client who pretty much had this exact same scenario, right? And he said, "Guys, I'm sick and tired of being jerked around. My priority date's been current 3 times, and well, we did just this. We gathered up some medical exams. He said, I'm going to try to make a push to get this thing approved." We gathered up some medical exams. What else did we say? Medical exams, and we just wrote a polite letter saying, "Hey guys, he sent a bunch of tubs. Here's a current approval notice for his a current supplement J for his EB3 category. He's in the EB3 category. His priority date's current in February. Approve the case." And well, sometimes you never know whether it was us doing the work or maybe they just got to his case, but he got an approval notice, or approval email. His case, one of his those I-45 cases went to status approved on Friday. So
Fantastic.
I know, I'm happy.
That's
happy
good
for
work.
him.
Yeah. So push for the EB3.
Yeah.
Yep.
You can, if you send
he has a correction on the second page. Says did tub to EB2. So it's
yeah. So okay, so
do a tub to EB3.
Yeah, I guess another bit of commentary.
Or shall you wait?
Remember, like
it's very close now in EB2.
Yeah, that's a good point. Remember, like in maybe like around a year and 2 years ago, I guess we started getting calls from confused USCIS officers and local field offices going, "Hey, I'm looking at your client's case here, and I see they have like two cases here. Which one do you want me to, 2 options, 2 employment-based categories. Which one do you want me to decide?" I don't think the government really knows where anybody's case is until you tell them to look at it, which is why I advocate, putting together a little package.
That's why I don't believe the government has any idea that they say, "Oh, we're very much aware of how many duplicate."
Yeah.
No, they don't know.
They don't know what categories anybody is in.
They have a computer that spit out a number, but based on very, very sketchy data, and they think they have a number, but I don't think that number is
I want to read
accurate.
that version of the FAQ. We have no clue. We want to assure you we have no clue what's going on. We have no handle on these numbers whatsoever. Rest assured that we are wasting away visas due to our absolute lack of information.
Yes.
Thank you.
Yes.
Yeah.
All right, next one.
Yeah.
Advanced parole I-131. I would like to renew my I-131 as per new USCIS guidelines. Can we file advanced parole online? Do we need to pay a fee for I-131 renewal? So as a 4-1,
They changed
the rule, and I don't. I know for a fact the I-765 there's a fee. I'm pretty sure the I-131 has a fee, but before April 1st, there's not a fee.
Well, here's the beautiful thing about USCIS online systems. They're not going to allow you to file your case without a filing fee or a waiver of a filing fee if it's appropriate in your case. And you'll find.
Right now you don't have a filing fee today.
Yeah.
February 26, 2024. There's no filing fee.
For renewal of an advanced parole based upon a pending adjustment of status. Yeah.
Yes.
Yeah.
Will the Department of Justice expand the H-1B stamping pilot program beyond year to 20,000 in the near future? No information that I'm aware of.
Yeah.
The idea is this pilot program is to expand and have a feel for what's going on. So the idea is to expand it, but we have no updates.
Yeah. I mean, one can hope because. Sooner or later, I guess they'll publish data about this program, and it'll be one of those things. We did great work. We gave away. We did this process. We gave out some visas. Very good at us. But I mean, one of my big complaints about that pilot program is no H-4s. It's
insanity.
Yeah, it's The members of the family most likely to want to travel and without the risk of coming back are the ones who with not coming back are the ones that are not impacted favorably by it. Yeah. All right. We keep it going here. Prasad, case remains pending. I-45. We're temporarily pausing work on your application because the immigrant visa number is not immediately available to you. Once the immigrant visa number becomes immediately available, I'm going to see if I can find the other half of Prasad's talk here, Prasad Bodapalli. I don't see it there, so I'm going to have to presume that there's a. Well, Sam, what does that case remain pending mean?
It's true. I mean, it's one of the most. If the priority is not current, the priority is not current.
We can't give you a green card. We're going to put this up on the shelf. But
that's a good. That's the most accurate message I've seen among all the mumbo jumbo that they put out.
Yeah, I mean, I'm going to use this as an opportunity to advocate. If you think your priority date is current, and you think they can improve your case, if you send a nice little package to them reminding them, you have everything. My priority is current now. You have everything you need to approve my case. One thing the government does have systems for taking mail. If you somebody eventually has to get that into your file, and if it gets in front of the right person, and you tell them look at my case. There's a chance that you can get them to actually look at your case faster than they might have otherwise done.
Yep.
Yeah.
All right, so let's go to the next one here.
Yeah, I think that's a repeat. Let me see here from.
When is my 2022 priority be current for EB1C category? Obviously. EB1 is EB1, first of all.
Yeah.
Doesn't matter.
Yeah.
And if you are from India, we're going to see a rapid advancement just because the rest of the world is current.
Yeah.
We believe that there will be a rapid advancement all the way to July 2022 because I see China is July 2022. So India gets the lion's share.
Yeah.
Until it hits July 22. So I can see quick advance to July 22 soon, and then beyond that, it may slow down. But in terms of timeline, it's very difficult to kind of predict.
Yeah, I agree with everything there. I mean, out of curiosity, dates for filing. That's a shame. He's not candidate. This person hasn't, if presuming born in India. There are EB1 even dates for filing are still in January of 2021, which is a bit rough.
Yep.
Okay. From Prem. A question near and dear to your heart, I think, Sam. I'll read it, but you can answer because you have some opinions. Can USCIS/DOS count the number of Indians filed in both EB2 and EB3 categories? I feel like moving EB3 ahead of EB2 makes applicants file in both categories. USCIS needs to move EB2 ahead of EB3.
It's an excellent point. But when they move it ahead, there's expectation of issuing green cards.
Yeah.
And if they don't have green cards to issue, it's a problem. And I'm not going to advocate moving EB3 back behind in EB2 because
the visas are apparently available.
It's going to get people upset, and it sounds like the visas are available.
Yeah.
As you know, that these dates throughout the year are estimates. The only requirement by law is for them to have a good faith estimate every quarter, not every month, every quarter, and to use up all the green cards by the end of the fiscal year, which they never do.
Yeah, very upsetting.
And therefore, don't get caught up between these little dates because honestly, it's just a guess game.
Yeah.
And it will continue to be a guess game until there's a complete overhaul of the counting system, and which is probably cost prohibitive to do.
Yeah.
Right now, under the current situation that we have.
Well,
There's
yeah.
absolutely no way to track.
Changing the way we keep track of these, doing a better job of keeping track of.
Yeah.
I like to think there should be, and there should be, like, we have a system in which we track our cases. I like to think that the government should have one where they type in, Prem, and, just change a little flag there. It says, EB2, when they get a transfer underlying basis, and then, we're through that, change it back to EB3.
How about the employee logs in and change the flag, and
Upload a supplement J at the same time.
There's a motor in the back that says, okay, yeah, you can do it, or no, you can't do it.
I'll get you a quote. I'll get my team on it. I'll get you a quote for that. $50 million.
And it's not going to work.
Yeah, it's not going to work for sure.
And the problem with it, in their defense a little bit, is because Congress, although they haven't done it in a long time, wait until they come out with something like this, and then they change the law upside down. And now you have to redo everything. Yeah. So that's part of the problem. Is obviously a lot of these situations are very fluid at times. All right, let's take the next one.
Okay, from Berkshire. Hello, with 2022 September priority date under EB3, other workers, rest of the world. Any chance I can be helpful around the end of the calendar year? So 2022 September. For EB3, other workers, I can't really say that I'm going to be any sort of 2022 priority date for EB3, rest of the world, other workers. Why? I'm looking at the final action date right now for March 2024. I'm seeing it's in late 2020, September 2020. I can't really, that's pretty far off from 2022. I look at even the dates for filing for EB3, rest of the world, other workers. I am seeing December 2020. I don't mean to burst a bubble, but fundamentally, that's dates for filing represent where the final action dates are going, and the final action dates allegedly are going to December 2020 in the near future, and 2022 is a long time off. Is the bottom line. Yeah.
Good point. I agree.
Yeah.
Arun is the next one. Keep insisting that the second change was to EB2, not to EB3, one higher.
Okay,
yeah,
I see.
And therefore, you made two requests to me to change your underlying basis to EB2.
Yeah.
And you have to, you should be in EB2.
Well, but what if he wants to be in EB3 right now?
But he filed for EB3, and he filed a tub a few months later, changed employer, and filed another tub. Both requests are in EB3.
Yeah. I just don't, I imagine my great big immigration revolution was a little system in which they check a box to indicate what category you're in. I don't think they know. I think they maybe know what your priority date is, and maybe they look at it when your priority dates.
So let's assume you changed your tub twice to EB2, and your EB3 is current. I would send them the medical, and I would request to adjudicate the EB3.
Yeah.
I would completely forget that you filed EB2 tubs twice, and let them adjudicate
Yeah,
it.
well, the guy I did it for.
And they probably will do it.
Yeah, the guy who I'm thinking of, there was basically I believe he tubbed to EB2, then he withdrew it to go back to EB3 sometime like a year ago. And I said, I sent a letter saying, just as a reminder, he actually did withdraw that request, but we're not going to leave anything up to chance. So what we gave them was the medical exams and another, supplement J, because they do love to ask for supplement J's. If they have a case that's been sitting for a while, what do? They say, got to make sure we can approve this green card. We might issue an RFE, get a supplement J, make sure you haven't violated, worked without authorization, anything like that, to get your medical exams. Or you might be able to preempt that and send in a package that's saying, hey, here's everything you need. Prove my case.
Yep.
Yeah. So 6:56 here, and I think we've kind of reached the end of our questions a little
Sounds
bit
good.
early.
Yes, that's fantastic. Well, thank you guys for listening to us. Hopefully this was helpful. And 6 o'clock Monday, we'll come back and do it.